Welcome to the Family Law Channel. Today, the three-judge federal appeals court panel, the Ninth Circuit, has ruled that the voter-approved ban on same-sex marriage in California is actually unconstitutional. What this does is it assures that this will head to the Supreme Court. My guest is the host of the Family Law Channel, the Honorable but retired Judge Eugene Hyman, Superior Court, California, Santa Clara, California. Judge Hyman, welcome back.
Thank you.
So I guess no big surprise. Those who watch this have said, well, you know, the Ninth Circuit is a liberal court. What does this do, do you think?
Well, it's huge in several senses. One, it's important to remember that what they did was within the context of the California Constitution, and that this doesn't necessarily have a bearing with respect to other states, or even other states that have constitutional provisions prohibiting gay marriage within states that are presently within the Ninth Circuit, which, as you know, is the largest circuit within the United States, and has a number of states that are within its borders, because they limited themselves to a discussion of the California Constitution, and that it violated due process within the meaning of the California Constitution. The other thing is whether or not the proponents of Proposition 8, those that are in favor of outlawing gay marriage, will request the circuit as a whole, referred to as en banc, to decide the issue, which isn't actually every judge on the court. It's, I believe, half the judges on the court sit en banc, and they will, if they do, if they're requested, and if in fact they do, then they will decide whether or not to uphold the three-judge panel or to reverse them. They do a lot of en banc within the Ninth Circuit, and one of the reasons for that is because they think that if they do that, that it's less likely to get Supreme Court review than with respect to just a three-judge panel. If, in fact, the entire court considers it, and if they still determine that it's against the California Constitution, that does not necessarily mean that the U.S. Supreme Court is going to take the case, because remember, nothing forces the Supreme Court. They decide for themselves whether they're going to hear a case or not. If they refuse to hear it, whether it be from a three-judge panel or whether it be from an en banc panel, then that's it. That's finished. Now, the other issue is they left in force the stay prohibiting gay marriages in California. The opponents of Proposition 8 are going to be requesting that the stay be lifted, and which would be appropriate depending upon what in fact happens. Whether if they don't request within a certain period of time that the entire court hear the matter, then it would be appropriate to dissolve the stay. If the Supreme Court then decides to hear it, then it might be appropriate to keep the stay in place. Clearly, if the Supreme Court does not hear the stay, or if en banc does not hear it, or if the en banc upholds the three-judge panel, then it would be appropriate to dissolve the stay, in which case then gay marriage would again be lawful in California.
All right, it sounds like, I want to ask you one other question though, and you know, some of those who are gay marriage proponents have been kind of apprehensive about this going to the Supreme Court, which is what I think you hinted at earlier, because it, you know, that the Ninth Circuit's great, but we could. You're saying it's possible we could get a completely different decision in the Supreme Court?
Oh, absolutely. I'm not saying that they will, but they certainly are capable of reversing. And the Ninth Circuit, as you know, has the highest reversal rate of any circuit. But in part, that's also because it's the largest circuit and it issues the most opinions.
Right. And you also said that this doesn't affect any other states, but it's such a big decision, and in a big state, don't you think it will affect other states who will be considering this issue differently?
Well, yes, but it also depends upon how those constitutions read in terms of how they define privacy and how their court cases within the state have defined privacy. California, for example, this is consistent with California's definition of privacy even within the meaning of abortion. California abortion is much more liberal than most of the other states, and regardless as to what happens with respect to the abortion issue nationally, Many commentators predict that abortion will always remain legal in California because of the expansive privacy statement within our state constitution, which is the same privacy that dealt with the issue of gay and lesbian marriage.
Now, when you look at this decision, although they say that the ban on gay marriage is unconstitutional, it didn't really, draw any grand constitutional right for gay marriage. Is that a big issue here, do you think?
Well, you're correct, and that they are very careful to limit their decision in terms of how they discuss it. And it's one thing to say that you cannot prohibit it within the confines of the California Constitution. Another is to say that you have a constitutional right to get married, and there is a subtle but an important distinction between the two, especially if you're talking about trying to expand this issue to the other 49 states.
All right. Well, we appreciate you taking the time out of your busy day, Judge, and thanks for lending us your expertise here.
Thank you.
You're watching the Family Law Channel here on the Legal Broadcast Network.